You're driving home. Red and blue lights flash behind you. Your heart drops because you know there's a legally owned firearm in your glove box. The officer walks up, and before he even asks for your license, he says, "You got any weapons or drugs in the car I should know about?" Every single day, law-abiding gun owners and regular people talk themselves into arrests with one sentence. Today I'm showing you the 5 things you must never say to police about guns or drugs, the exact legal traps behind each one, and the 4 phrases that actually protect you. Never admit. Number 1. Yeah, I have a gun. Here's the first trap most gun owners fall into. The officer asks, "Do you have any weapons in the vehicle?" And you think honesty is the best policy, so you say, "Yeah, I have a gun in the glove box. I have a permit." The moment those words leave your mouth, you've just given the officer everything they need. Picture this. You're a legal gun owner, valid concealed carry permit. You've done everything by the book. The officer asks about weapons, and you say yes. What happens next? The officer's hand immediately goes to his sidearm. His body language changes. He calls for backup. You hear over the radio, "Occupant admits to firearm in vehicle." Suddenly, you're being ordered out of the car with your hands visible. The gun you legally own is now being treated as a threat. Your honest admission just turned a routine traffic stop into a high-risk encounter. Here's why people do it. Gun owners think disclosure shows respect. They believe being upfront proves they're not hiding anything. But here's the legal reality. In many states, you're not required to voluntarily disclose unless specifically asked, and unless your state has a duty to inform law. When you blurt out, "Yeah, I have a gun," you've created reasonable suspicion for the officer to extend the stop, search for that weapon, and potentially claim officer safety concerns that justify almost anything. On camera, your voluntary admission gives legal justification for everything that follows. The correct response when an officer asks, "Do you have any weapons in the vehicle?" is this: "Officer, I'm invoking my Fifth Amendment right. I prefer not to answer questions." If you're in a duty to inform state with a firearm actually on your person, the better approach is, "I'm going to hand you my driver's license and my carry permit. I'm not reaching for anything. How would you like me to proceed?" Notice the difference? You're not volunteering information. You're not admitting possession. You're complying with the specific legal requirement in the safest possible way. This keeps control. It doesn't give them grounds to extend the stop. Remember, cooperation does not mean conversation. Be respectful, not talkative. Bottom line, never volunteer that you have a weapon. Even legal gun ownership becomes evidence once you admit it. Never admit. Number 2. I smoked earlier, but I'm fine now. The second trap is the past drug use admission. This catches people who think honesty about what already happened can't hurt them. The officer asks, "Have you used any drugs or alcohol today?" You think you're being smart by saying, "I smoked some weed this morning, but that was like 8 hours ago. I'm totally sober now." You just confessed to DUI. Let me show you how this escalates. The officer says, "Step out of the vehicle." You comply. Now he says, "I'm going to conduct some field sobriety tests." You think, "Fine, I'll pass them because I'm not impaired." But here's what you don't know. Field sobriety tests are designed for alcohol impairment, not marijuana. The officer's not looking for actual impairment anymore. He's building a case based on your admission. Every tiny misstep, every moment of nervousness gets documented as consistent with marijuana impairment. 30 minutes later, you're in handcuffs. Your car's being searched. Your blood is being drawn. All because you thought explaining the timeline would help. Here's the legal reality. In most states, it's illegal to drive with any amount of certain drugs in your system. It doesn't matter if you smoked 8 hours ago or 2 days ago. If you admit to recent use, the officer now has reasonable suspicion for a DUI investigation. Your blood test will likely show THC metabolites, and your own words become the prosecution's best evidence. From the Supreme Court case, Salinas versus Texas, we know that your statements can be used against you even in casual conversation. That 8 hours ago comment? That's Exhibit A at your DUI trial. On body cam, you just admitted to drug use and then got behind the wheel. Here's the wrong way. Officer asks, have you used any drugs today? You say, well, I was at a party last night and I might have had something, but that was like 12 hours ago and I'm completely fine to drive. Here's the right way. Officer asks, have you used any drugs today? You say, officer, I'm invoking my Fifth Amendment right. I prefer not to answer questions. If the officer says, are you refusing to cooperate? You respond, I'm here to provide my license, registration, and insurance as required. Beyond that, I'm exercising my right to remain silent. You gave 0 admissions, 0 timeline, 0 evidence they can use. Silence is your strongest defense. Bottom line, never explain past drug use. Never provide timelines. Never try to minimize by saying, it was earlier. Never admit. Number 3, it's just a little bit. The third trap is minimization. People think if they downplay the amount, it somehow helps. It doesn't. The officer says, we found a baggie in your center console. What is that? You say, oh, that's nothing. It's just a little bit of weed. Barely anything. The officer responds, so you're admitting this marijuana belongs to you? You say, I mean, yeah, but it's just personal use. It's not like I'm selling it or anything. In 30 seconds of trying to minimize, you just confessed to possession and established that you knew it was there and admitted it was yours. Every single element the prosecutor needs to convict you just came out of your mouth. Here's why people do it. They believe minimizing the amount will result in leniency. They think it's just a little bit sounds better than staying silent. But quantity doesn't matter for the charge. In many jurisdictions, any amount is still possession. More importantly, your statement that it's not like I'm selling it actually introduces the concept of distribution into the conversation. Now the officer can ask about scales, baggies, texts about selling. You just opened a door you can't close. Here's the wrong way fully demonstrated. Officer asks, what's this in the door panel? You say, look, it's just a tiny amount. I wasn't even planning to use it. My friend left it there. Officer asks, so you knew it was there? You say, well, yeah, but I was going to throw it away. Watch what you did. You admitted knowledge. You admitted it was there. You even created a consciousness of guilt statement by saying you were going to throw it away, which proves you knew it was contraband. Here's the right way. Officer asks, what's this in the door panel? You say, officer, I'm invoking my Fifth Amendment right. I don't consent to any searches and I'm not answering questions about what you may have found. Officer responds, so you're saying this isn't yours? You say, I'm exercising my right to remain silent and I want to speak with my attorney. Now the state has to prove possession. They have to prove you knew it was there. Without your confession, that becomes much harder. Silence protects every possible defense. Bottom line, never minimize, never quantify, never characterize. Any admission is still a confession that destroys your defense. Never admit. Number 4. My friend left it there. The fourth trap is the blame deflection. People think if they establish it belongs to someone else, they're protected. They're not. Officer finds drugs or a weapon in your car. You panic and say, that's not mine. My friend left it there. I didn't even know it was there. You just made everything worse. Here's why. There are 2 types of possession: actual possession and constructive possession. Actual possession is, it's in my pocket. Constructive possession is, I had access to it and knowledge of it. When you say, my friend left it there, you're admitting knowledge. When you admit your friend used your car recently, you're establishing your control over the space. You just proved constructive possession. Let me show you how this plays out. Officer says, there's a firearm under your seat. You say, oh man, my buddy must have left that. He went shooting last weekend and borrowed my car. Officer asks, so you knew about it? You say, no. I knew he had guns, but I didn't know it was still in my car. You just admitted you knew your friend had weapons and that he had access to your vehicle. That's constructive possession. Or this scenario. Officer says, we found pills in your glove box. You say, those aren't mine. I let my friend use my car and he must have left them. Officer asks, When did your friend use your car? You say like 3 days ago. You just admitted you've had 3 days to discover them and remove them, but didn't. That's knowledge and control. That's possession. In Texas and Ohio, constructive possession requires proof of knowledge and control. Your friend left it statement provides both. In California and New York, prosecutors can argue consciousness of guilt when you immediately deflect ownership. The correct response when an officer asks, "Whose is this?" You say, "Officer, I'm invoking my Fifth Amendment right. I'm not answering questions about ownership or anything else." Officer responds, "You're not going to help yourself out here?" You say, "I'm exercising my right to remain silent and I want to speak with my attorney. I do not consent to any searches." You gave them nothing. No knowledge statement. No control statement. Your attorney can now challenge whether you even knew it was there. Bottom line, never blame someone else. Never establish a timeline. Never give names. Every word of explanation is evidence. Never admit number 5. I didn't know it was illegal. The fifth trap is the ignorance defense. You think explaining you didn't know the law will excuse you. It won't. Officer finds something, and you say, "I didn't know that was illegal," or "I thought it was legal in this state," or "someone told me I could have this." You just admitted to knowing possession while trying to claim ignorance of the law. There's a legal principle that applies everywhere. Ignorance of the law is not a defense. When you say, "I didn't know it was illegal," you're admitting you possessed it. You're admitting you knew it was there. You're admitting you had control over it. The only thing you're claiming ignorance about is whether it was legal, and that doesn't help you. This comes up with firearms all the time. Someone travels from a state with relaxed gun laws to a state with strict gun laws. They get stopped. Officer finds the firearm. They say, "I didn't know I couldn't have this here. It's legal in my home state." You just confessed to illegal possession in this state. Your home state's laws don't matter. You're in this state now, subject to these laws. The same principle applies to drugs. I have a prescription in another state doesn't help when you're possessing controlled substances without a valid prescription in this state. I thought CBD was legal everywhere. Doesn't matter if you're in possession of THC products in a state where they're not legal. Stay calm, stay polite, but stay silent. The correct response is always the same. "Officer, I'm invoking my Fifth Amendment right to remain silent. I want to speak with my attorney." Bottom line, never try to explain what you thought was legal. Never admit possession while claiming ignorance. Stay silent. The 4 phrases that actually protect you. Now that you know what never to say, here's what you should say. These 4 phrases are your legal shield. Phrase 1. Am I free to leave? This establishes the legal status of your encounter. Use it first. If the officer says yes, you leave immediately. If no, you now know you're being detained. This comes from Terry versus Ohio. Say it like this. "Officer, am I free to leave or am I being detained?" Phrase 2. I invoke my right to remain silent. This is your Fifth Amendment protection. From Salinas versus Texas, you must explicitly invoke it. Silence alone is not enough. Say it like this. "Officer, I'm invoking my Fifth Amendment right to remain silent." If they keep questioning, "I've invoked my Fifth Amendment right. I'm not answering questions." Phrase 3. I want to speak with my attorney. This invokes your Sixth Amendment right to counsel. Once you say this clearly, questioning must stop. Say it like this. I want to speak with my attorney before answering any questions. Phrase 4. I do not consent to searches. This protects your Fourth Amendment rights. Even if they search anyway, your clear refusal gives your attorney grounds to challenge it later. Say it like this. Officer, I do not consent to any searches of my person, my vehicle, or my belongings. These 4 phrases cover every constitutional protection you have. Use them. Repeat them. Never deviate from them. Closing. Here's the core principle. The police officer is not your friend during an investigation. Every word you say about guns or drugs becomes evidence. The 4 phrases that protect you are, "Am I free to leave?" "I invoke my right to remain silent." "I want my attorney." "I do not consent to searches." Screenshot these phrases right now. Print them. Put them in your glove box. Practice saying them until they feel natural. This video is for educational purposes only and is not specific legal advice. Always consult an attorney licensed in your state. If this helped you, hit like, subscribe, and tap the bell. Share this with friends and family. Remember, your silence cannot be used against you, but your words always can. Be polite, be calm, but be smart. Stay safe out there.